The officer says 4 words, "Hand me your wallet," and before your mouth even opens, your hand is already moving towards your pocket. That reflex, not the officer's request, is what ends your constitutional protection in that exact moment. I have gone through documented court records and forfeiture filings where the entire outcome turned on what a driver did in the 3 seconds after hearing that sentence. There is no statute that requires you to surrender a wallet. There is one sentence that keeps every protection you have intact. Here it is, and here is the order it has to happen in. The reflex. Picture this. Lights flash behind you. The stop already happened. The license and registration already changed hands. And now the officer leans in and says, "Hand me your wallet." Almost everyone does the exact same thing at that moment. The hand goes to the back pocket before a single word comes out of their mouth. That is the reflex, and it is one of the most damaging habits a driver can have during a stop, not because reaching for your pocket is illegal. It is because handing over an object, silently and immediately, is read by courts as voluntary action. You moved before you spoke, so there is no verbal record of hesitation, no objection, no assertion of a right, just compliance. Officers are trained to notice this. A driver who acts before speaking has, in the eyes of the law, already made a choice. Stay calm here, because the fix is not complicated. The fix is sequencing. Say something first, move second. The exact sentence is, "I do not consent to any searches," and that sentence has to leave your mouth before your hand leaves the wheel. Here is how it actually sounds in the wrong order. Officer, hand me your wallet. Driver, already reaching, here you go. Officer, appreciate it. Mind if I take a look through what's inside? Driver, I guess. That guess is the whole case right there on tape. Here is the same moment done correctly. Officer, hand me your wallet. Driver, hands still on the wheel. I do not consent to any searches. Officer, I just want to see your ID. Driver, my license is already in your hand, officer. Same request, same officer. 2 completely different legal outcomes because of 11 words spoken in the right order. No legal basis. Here is what almost nobody tells you. A routine traffic stop gives an officer authority to request your license, your registration, and proof of insurance, run a records check, and write a citation. That is the scope. Legal scholars who have studied hundreds of these encounters describe that authority in exactly those terms. Nothing broader. A wallet is not a license. It is not a registration card. It is a private container holding cash, payment cards, receipts, and photographs that have nothing to do with why you were stopped. Even in states with stop and identify laws, the Supreme Court's ruling in Hebel versus the 6th Judicial District Court of Nevada made clear that a detained person only has to state a name. The court specifically said the statute does not require producing a license or any other document. If stating your name satisfies the strictest version of that law, then surrendering an entire wallet satisfies nothing except an officer's request, and a request is not a command with legal force behind it. Wayne Lefebvre, whose treatise on search and seizure law is cited in courts nationwide, describes the routine stop's authority as license, registration, and a records check, full stop. Nothing in that description reaches into a coin pocket or a stack of gift cards. When an officer says wallet instead of license, they are asking for something the routine stop was never built to include, and most drivers never notice the difference when it matters most. What's inside? Think about what actually sits in a wallet. Cash, sometimes loose, sometimes banded together. Credit cards from out-of-state banks, a gym membership, a hotel key card from 3 weeks ago. None of it relates to a broken taillight or a rolling stop. But once that wallet is open in an officer's hands, every one of those items becomes something a report can describe. Emil Woods was a truck driver from Mississippi, pulled over in Harris County, Texas, for following another vehicle too closely. He was carrying $42,300 in savings, meant to buy a second truck for his growing business. That cash, once discovered, became the entire case. No drugs were found. No charges were filed. The county kept his money anyway, and it took roughly 6 years and an appeals court reversal before a judge ordered it returned. Nationwide, one federal agency alone seized over $4 billion in cash across a single decade, and $3.2 billion of that was never connected to a criminal charge of any kind. Your body camera captures the exact second that wallet opens, and that footage becomes the government's evidence, not yours. Officers are trained to notice specific patterns once a wallet opens. Cash bundled with rubber bands, bills that are unusually crisp or unusually worn. Multiple prepaid cards. None of these things are illegal to carry. All of them have been cited in real police reports as contributing factors toward further investigation, turning a routine stop into something longer than intended. The consent loophole. This is the part defense attorneys spend entire hearings arguing over. In Schneckloth v. Bustamante, the Supreme Court ruled that consent to a search only has to be voluntary under the totality of the circumstances, and the government does not have to prove you knew you had a right to refuse. Silence plus a handed-over object equals voluntary action under that standard. And if you're catching how differently that plays out, compared to what most drivers assume, subscribe now so you don't miss the rest of this legal framework, because the next layer explains exactly how officers use it against you. Florida v. Bostick added the test courts still use today, whether a reasonable person would have felt free to decline the request and walk away. Handing over a wallet the instant it's requested tells a court you felt free and chose compliance anyway. That is the entire argument prosecutors need. You never said no, you never hesitated, you simply acted. And action without words is consent. The wrong version sounds like silent compliance. Wallet passed over, no words at all. The right version sounds like a spoken objection landing on the record before anything changes hands. Courts do not read minds. They read transcripts and body cam audio, and only one of those two versions gives a judge something to work with later. The gateway. Officers are trained to treat an open wallet as a starting point, not an ending point. Once cash is visible, questions shift immediately. Where did this come from? Why are you carrying this much? Are you employed? Every answer and every visible reaction while answering adds to what courts call reasonable suspicion. The Supreme Court's ruling in Illinois v. Wardlow established that nervous, evasive behavior is a legitimate factor courts can weigh when deciding whether an officer had grounds to investigate further. So the shaking hand that pulls a wallet out too fast, or the voice that catches when asked about the cash inside it, becomes part of the record against you. This pattern shows up again and again in suppression hearings across the country. The wallet does not just reveal what is in it, it reveals how you behaved while revealing it, and both pieces end up in the same body cam footage the prosecution plays for a judge later. It plays out almost the same way every time. Officer, that's a lot of cash for someone driving a car like this. Driver, I don't know, I just carry it. Officer, you seem nervous. Is there a reason for that? That single exchange, stacked with a hesitant answer, is often enough for an officer to request backup or a canine unit, stretching a 5-minute stop into an hour, so stay calm and let the words carry the weight instead of your nerves. Real cases? Strawn Gorman was pulled over on Interstate 80 in Nevada for driving too slowly in the left lane. The trooper asked whether he was carrying large amounts of cash. Gorman said he had about $2,000, a fraction of what he actually had. Then the trooper asked to search the vehicle. Gorman said no, out loud, on the record. The trooper let him go, then arranged a second stop down the road with a drug dog. That second stop turned up $167,070 in cash. No drugs, no charges. The government tried to keep the money under civil forfeiture anyway. It took a federal judge, citing Rodriguez v. United States, the ruling that bars officers from prolonging a stop beyond its original purpose, to order the cash returned years later. Gorman's spoken refusal became the single most important piece of the entire case record. It proved he never consented to anything. Without those words on tape, the outcome almost certainly goes the other way. Compare that to Emil Woods, whose savings sat vacuum-sealed in his trunk rather than a wallet. Discovered during a search he never verbally authorized on record. His case ended in a civil jury verdict against him in 2023, before an appeals court reversed it in 2025. Two different drivers, two different objects holding cash, but the same lesson each time. What ends up on the recording decides the case far more than what ends up in the search. The correct sequence. Here is the order that protects you. The moment you hear "hand me your wallet," your mouth moves first. Say it clearly and without hostility. I do not consent to any searches. That sentence is not just a search refusal. It is a formal objection your officer's own body camera now permanently records before your hands do anything at all. Next, ask directly whether this is a request or an order, because those carry different legal weight. If it is a request, you can decline and simply produce the license and registration you already lawfully provided earlier in the stop. If the officer frames it as an order, say this while complying: I am complying under protest, and I do not consent to any searches. Stay calm through all of it. Your tone matters as much as your words. If questioning continues past the basics of the stop, add, I invoke my right to remain silent. If the encounter escalates further, ask, am I free to leave? And if you are told no, say, I want an attorney. 4 sentences, spoken in the right order, do more to protect you than anything physically inside that wallet ever could. Officer, come on, just hand it over. It will take 2 seconds. Driver, I hear you, officer, and I do not consent to any searches. My license and registration are already yours. Officer, I'm not trying to search you. I just want to look. Driver, I understand, and I do not consent to any searches. That repetition is not stubbornness. It is the sentence doing its job twice, calmly, on camera. After you say it. Once those words are on the record, the officer's options actually narrow. Under Bostick, a court now has a recorded verbal data point showing you did not feel free to simply comply, which cuts directly against any later claim of voluntary consent. Most encounters end there, with a citation or a warning and nothing else. The core principle of this entire video is simple. Whoever speaks first controls the legal record, and a wallet handed over in silence writes a story you never agreed to tell. Remember your 4 phrases. Am I free to leave? I invoke my right to remain silent. I want an attorney. I do not consent to any searches. State law changes what happens after the stop, even when the stop itself goes the same way everywhere. Maine, Nebraska, New Mexico, and North Carolina have eliminated civil forfeiture without a conviction entirely, meaning prosecutors need a conviction before permanently keeping seized cash. Massachusetts currently holds the worst forfeiture grade in the country among independent legal rankings. Colorado just closed a major loophole in 2026, requiring a conviction before forfeiture proceeds in most cases there now. Know which category your state falls into before you're pulled over. Practice the sentence tonight, out loud, until it comes out before your hand moves toward that pocket. Write these 4 phrases on a card and keep it in your glove compartment, since rehearsal now is what makes the words automatic later. This is educational content based on documented court records and case law, not legal advice for your specific situation, so consult a licensed attorney in your state before relying on any of it. If this changed how you will handle that moment, like this video, subscribe for the rest of this legal framework, and hit the bell so you never miss it. Tell me in the comments what is actually in your wallet right now that you would not want an officer flipping through. Someone pulled over an hour from now needs this exact sequence, so share it before they need it. Your hand follows your voice, never the other way around.